we have Robert Finlay. He's been practicing since 92-ish, about, yeah. When he's not practicing law, he's playing pickleball, apparently, and I don't know if he's any good, but I hear he is. So with that being said, here's Robert Finlay from Zach Finlay and Wright.
All right, thanks, Jeff, and thanks, Chris, for having me. I really appreciate being invited back again to speak this year. Hopefully, apparently I didn't depress everybody so badly last year talking about litigation. But I will say the first thing I did when I got here, first thing I ran into Dr. Thornburg downstairs, said hello, immediately ran upstairs, talked to Brittany and said, I hope I'm going before him and not after him, because if you have not heard Dr. Thornburg speak, you'll very quickly realize why I did not want to go after him. So hopefully I can do this right here. There you go. All right. Well, I'm going to talk about litigation. First, a little bit. Robert Finlay, Wright, Finlay, and Zach. We help our private lending clients with mortgage-related litigation, compliance, regulatory, bankruptcy, eviction matters, and when your title company denies your title claim, we help pester them or sue them to make sure they honor the title claim. Sorry for any title officers here. It's not your fault, it's your coverage people. Also, side job is general counsel for the California Mortgage Association. And if I had pie charts, I would put my pie chart up there, and my pie chart would say that 99% of the loans I see are in default. And of that, probably 98% of those are involved in litigation. So my pie chart's very, very different because I only see the ones that are in litigation. I only see the ones in default. So it was interesting to see Chris's slides that show that there's so few that actually are in that situation. But unfortunately, that tends to be what I see. So along those lines, I'm going to talk about litigation trends and what I'm seeing these days. And some of this may be some things people in the room have seen or have heard about, but I'm going to kind of run through the litigation we're seeing as well as hopefully some practice tips to help you avoid some of that litigation. So I'm going to talk about default interest, although Chris kind of summarized it, so I'll go quickly on that. But no, default interest is an ongoing issue. Even though the case law changed about 1.5 years ago, and it's something we've talked about a lot, I still get calls, probably 2 or 3 a week, asking about, can I charge default interest in this situation? What about this situation? Or I charged it previously, and am I in trouble? So we'll kind of run through some of that. I'm also going to talk about the In Re Moon decision, which has been an evolving decision since last year, and it affects whether you can and can't do forbearances, extensions, and modifications when you're trying to work with your borrower to avoid foreclosure. And then I'll kind of lastly just talk about just some general litigation trends and some other types of cases that we're seeing. But like Chris, I'm going to grab my glasses. There we go. And the slides will be available if anyone wants them later. You can reach out and I can give them to you, or maybe Brittany will send them around. All right, so default interest first. Everyone will get all the slides, so they'll be sent around to you later, so you don't have to take very detailed notes. But so the baseline analysis for default interest, and this is getting a little bit into legal weeds, which I hate to do, but I think it's important to understand what you can and can't do, which is what I'm going to get to in a couple slides. So default interest is not evil, it's not bad, and it is permissible. It is permissible to compensate the lender for anticipated additional cost, delay, and loss resulting from the default. That's the purpose of it. However, it can be an unenforceable penalty if it is primarily for the purpose to compel prompt payment, which sounds kind of funny because we all know that's really why we're charging default interest, is to keep the borrower honest and keep them coming back, bring the loan current and avoiding default. That part's okay. It's the second part of the quote there, which is that if it doesn't bear a reasonable relationship to the amount of the actual loss that is being incurred. So, and that's where we get into the case law and the statute that applies. And in the nutshell, what the slide says is that in order to charge default interest, it must bear a reasonable relationship to the loss that you thought you were going to suffer as a result of the default at the time you entered into the contract. Not later, not today, but the time you entered into the loan, you knew that if this goes into default, I think I'm going to suffer this amount in damages. And as long as the default interest bears this reasonable relationship to that, you should be fine. And the borrower, it's the borrower's burden in a non-consumer situation to challenge the default interest. It's up to them to show that there is no reasonable relationship. And that's always been the case law. It's been, I cite the Wrigley case, it's since 1998, but you can go back to 1897, there's a case talking about the exact same thing. What changed is how the court decided to, I'm going the wrong way, there we go. There we go. So what changed is this Honsharu case. Came out in 2022. And the facts of the case, it's a non-consumer bridge loan, and it had actually a very modest default interest. The loan rate was 8.5, and it went up to 9.99, so only about 1.5% interest. So not very much at all, compared to what I generally see, which is 4 or 5, or even up to 10, 12. The note had the standard default interest provision. The borrower fell into default, and the lender started charging default interest. This is all pre-maturity. So missed payment, default interest charge. Very common scenario. The borrower sued, went to arbitration, and the lender won. So great. But then it went up ended up going to the Court of Appeals, and the Court of Appeals came back. And they basically, the first part of the decision, I can't remember too many decisions I read. I'm like, all right, I'm following this. Everyone tells me this is really bad. It came out yesterday, and I'm reading along, and I read the first part of it, and they start talking about in the non-consumer context. It's the borrower's burden to show that there's no reasonable relationship between the default interest you're charging and the anticipated loss. Great, they got it right. And then the very next sentence, or paragraph, I'm expecting to read this discussion of whether there was or wasn't a reasonable relationship and the evidence that the borrower presented and the lender's counterarguments. But instead, the court immediately went to any time you charge default interest following a payment default. So this is prematurity. Following a payment default, anytime you charge it, it is per se unreasonable. So they said there's got to be this analysis, but then they skipped the whole analysis and just went straight to if you're charging it post or after a payment default, it is not allowed. So that's why we're not charging default interest following a payment default like we did before. But I'll get into some of the things you can and can't do, because this is the questions that we get quite often. When can a lender charge default interest? On the entire unpaid principal balance following a maturity of the loan. Okay, so we know we can still do that as of now, until someone charges 20% default interest and the Court of Appeals comes down and says none of us can do anything. Because that's usually how we end up with bad decisions, is you have bad facts that lead to bad decisions. You can also charge default interest on the amount of the default. So if you miss a $10,000 payment, you could charge default interest on that $10,000 payment, provided that your contract says you can do that, and provided that you're allowed to charge compound interest, your agreement allows for that. That isn't that exciting. Default interest on a missed payment isn't that exciting, but you still can do it. What we know we can't do is we can't charge default interest on the entire unpaid principal balance following a payment default. We also know, and this is the backstop, we always have to remember, you can't charge default interest in any amount if it does not bear a reasonable relationship to the loss that you might suffer as a result of the default. So that's what we know we can do, can't do. The gray areas. So one thing that's unclear is whether you can charge, so the idea is if you can charge it when it's matured, the question comes out is like, well, what if it's accelerated? Can I charge default interest? Very similar. Entire principal's due and owing if it's matured. Entire principal balance is due and owing if it's been accelerated. We don't know the answer to it. This is one of the gray areas that comes up quite often. My feeling is that if you're charging it following a non-payment default, and so you send out your notice saying there's a non-payment default, and that may be, it may be an unauthorized transfer. It may be if your agreement says that you're supposed to provide tax returns every year or do something else, and you don't do it, that's not a monetary default, and you send out the notice and they don't cure it, then you go ahead and accelerate the loan and you charge default interest from the date of acceleration. We don't know if that works. It may very well work. At least from my standpoint, I can walk into court and say, Honsharu doesn't apply because, number one, this was a non-payment default, unlike Honsharu. Number two, the loan is accelerated, unlike Honsharu. So at least gives us a fighting chance. So the next question we got is, okay, well, if it's accelerated, if you can maybe get away with that and it's accelerated due to non-payment, or a non-monetary default, what if it was accelerated due to a payment default? It's still accelerated, same situation. That one makes me a little more nervous because it's harder to distinguish from the Honsharu case, and I'm afraid that a lot of our judges would not take the time to really think through that this is a non-payment versus a payment default. and they may just blindly follow the hunch through. That makes me a lot more nervous. The third area is some clients call and say, well, what if I charged default interest on less than the entire unpaid principal balance? We don't know. I think that I'd like to think that it gets us out of Honshru and gets us back to putting the burden on the borrower to show that there's no reasonable relationship. Okay? But then I get some clients that are like, well, oh, fine, I'll do it on 99%. I mean, come on. You do that, and I mean, they say it tongue-in-cheek, but you do that, and we're going to all end up in trouble. But if you came in and did 10%, charged default interest on 10% of the unpaid principal balance, we look pretty good going into court. 50%, not as good as 10, but better than 90%. So a lot of it's going to depend on our judge, but it's going to also depend on the amount of the default interest. So that case that we want to take up to the Court of Appeals to help us all and get a good decision would be we don't want a 15% default interest rate and you're charging it on 90% of the unpaid principal balance. We want the one that is a 4% default interest and we're charging it on under 50% of the UPB on the loan. So those are some of the gray areas. Some of the litigation risks with default interest. Pending litigation. So we're seeing a lot of litigation over default interest. And it's a combination, comes from two different angles. One is investors who are still charging default interest, they don't know about Honshru or they don't care about Honshru and they're doing it anyway. And some of, I'll get to that in a second point. The other is default interest that was charged a year ago, 2 years ago, 3 years ago. The statute of limitations is arguably 3 years, maybe 4 years, depending on the claims. And so we're getting litigation over default interest that was charged before Honshru came out in 2022. We're arguing that decision was a change in the law, and therefore it's not retroactive. But I understand, I could see the arguments that are being made on the other side. And so that's something we're battling over right now. One of the other issues that comes up is demanding, I get this question all the time. Can I just demand default interest with the intent to waive it if challenged? People get that question all the time. So I'm just going to go ahead and put it on my payoff statement, and then if they complain about it, I'll just say, no, I'm not going to do that. I don't like that approach. Charging default interest has risks associated with it. It's not just that you won't be able to collect it or they won't be able to charge it. They could pay it and then sue you afterwards. They can, and also just demanding something you're not entitled to it's a breach of contract. It can give rise to a host of other causes of action, all of which can expose you to liability, and all of which can then, if the other side prevails, they get their attorney's fees. So that is a common question and one to stay away from. The other question is, well, what if I charge default interest pre-Honshru? Should I give it all back? And my general answer is no. I think if you've charged it and you've already collected it, I wouldn't run around and start sending out checks to everybody. Obviously, there's the financial aspect of it, but I also think it opens a can of worms for you. What if you hold a second and the first is charging default interest? So it's someone's being very aggressive, doesn't know about Honshru, and they're charging default interest. And you hold a second, and you're going to have to reinstate that first or pay off that first. You have the same rights as the borrower in that situation. If someone's charging something on a loan that's ahead of you that they're not allowed to, you have a right to go ahead and challenge that. So the biggest takeaway that I wanted you to get when it comes to default interest is don't listen necessarily to what I'm talking about up here. We're all in a social situation talking, and I can't give legal advice here. But call your attorney, whether it's your in-house attorney, whether it's your best friend that's your attorney, just talk to any attorney before charging default interest. That's the biggest takeaway I would like you to get from it. All right, I can't see this either. Okay, so next we're going to talk about In Re Moon, which was a case that has got a lot of press the last couple of years. And this is probably, or last year or so, this is probably the biggest issue that's affecting the private lending space, in my opinion, right now. It only matters if you're charging, if your interest rate's 10% or above. If you're under 10%, then what we're going to talk about right now is generally not a concern or problem for you. So the Moon was a lawsuit that got filed. The facts real quick, it was the lender made the loan. The lender was not licensed. However, there was a broker representing the borrower. So as a result, they were able to exceed the usury limits of 10%. So California has a usurious limit of 10%. You can't charge more than that unless one of the exceptions apply, and there's enough exceptions to drive a giant semi-truck through it. The big one that matters to all of us is the broker exemption. So if the loan is negotiated or arranged by a licensed real estate broker, you can exceed 10%. Great. This particular case, it was, no problem. Then later on, the loan went into default, and the lender, on their own, without the licensed real estate broker, negotiated they called it a settlement agreement. It was ultimately deemed to be a forbearance agreement. I would call it probably a loan modification. It lowered the interest rate from 11.3 to 11.05, so you're helping out your borrower to avoid foreclosure. Great job. And what do you get in return is the court comes down and says, no, you violated the usury laws. And there was a bunch of different arguments made. The last point is the most important. The first three, you can read them up there. It's not, they were not, I don't think they were very strong arguments. But the last one, or strong, not arguments, but strong or relevant rulings by the court. The last one, the court said in what we call dicta, which is basically means it was like in a footnote. They said that even if a lender or a licensed broker had been involved in the negotiation or arrangement of that loan modification, it wouldn't have mattered, because it needed to be the licensed broker that was involved in the origination of the loan, so it needed to be the same broker, and that transaction, that loan had to be part of a purchase or sale. In other words, it needed to be a purchase money loan, which most of us in this room don't make, these are refinances. So that means if you have a loan that is anything but a purchase money loan and you bring in the original broker, it makes it very difficult for you to do a forbearance modification or extension. And there's no real definition of what a forbearance is. Basically means, if you look it up, it means to forbear from enforcing your debt. Well, that could mean postponing your foreclosure sale. That could be doing a payment plan. That's kind of generally what I think of a forbearance. It could be modifying your loan, not foreclosing. So it opens up a giant can of worms from that standpoint. So that's the bankruptcy appellate panel. It goes up this last year to the Ninth Circuit. And the Ninth Circuit doesn't hurt us, but doesn't help us. They issued an unpublished decision, basically reaffirming everything that the BAP said. They didn't specifically address the issue that primarily causes us concern, but the BAP opinion is still citable, so this issue is still out there, and still a problem. So it's a big litigation hot button right now. We're seeing it over current forbearances. We're also seeing it over past forbearances that were done maybe a year or two ago. And it's all, again, something that even more questions about this than I get about default interest on a weekly basis is the concern about, I want to help my borrower. I want to give my borrower a forbearance. I don't want to foreclose, but at the same time, I don't want to expose myself to liability. So what are your options if you want to help this borrower out? You can refuse to enter into a forbearance. That's the safest. That doesn't really help your borrower out too much. You can go ahead and foreclose. You can reduce your interest rate to below 10%. Nobody really wants to do that, but if you're 10.5, it's not that painful to do that, to give yourself some added protection. Some clients are just saying, I'm not going to do anything, I'll issue a new loan. So pay off that loan with a new loan. You can do that. You can ignore the decision and argue from a legal standpoint that this was just, what I mentioned earlier, was just dicta, which means it's not part of the decision, and that the theory behind the BAP decision is something that the courts don't have to follow. It's risky, but it is possible. There are bankruptcy appellate panel. There are BAP decisions out there that other judges laugh at, that have been out there for 10 years, 15 years, or 30 years. And courts don't necessarily follow them. But do you want to be the one to challenge that? That depends on you individually in your particular case. Good news is we are working on a legislative solution. So the California Mortgage Association is sponsoring a bill, SB 1146. I'll say it again, SB 1146. Look this up, remember it. Reach out to your representatives and tell them what a great bill this is and how they should pass it. And why do they want to pass it? Don't tell them it's so that you guys can make money or anything like that. Tell them it's because you want to help your borrowers, because it's consumer friendly. That's our pitch. Our lobbyist for the CMA is confident that this is going to pass. I think the language is good. Primarily drafted. That's why I think it's good. But I think we're going to get it passed. But that's only going to help us going forward. But at least that'll fix the problem going forward. So keep an eye out for that SB 1147. Oh, sorry, 1146. Thank you very much. I'm also putting together a a article that's going to go out. So if any of you are on a newsletter that we send out articles, it's going to have a Q&A on all the questions that we get on a regular basis regarding moons, so that we don't have to answer the same question over and over again. So if you're not on my mailing list, distribution list, just let me know. I'm happy to add you. Okay, other litigation, real quick. Other litigation trends. My business purpose loan is actually a consumer loan. Every borrower is your friend when they make the loan. They love you. They want the money. They'll say whatever they want. They'll agree to anything they want. Often, though, sometimes they will say that this is, some brokers will come to them and tell them that they should say that this is a business purpose loan when, in fact, it's not. Unfortunately, that's a real problem out in the industry, not in this room, but in other people that are out there making loans. And it's something, and because of some bad actors that are out there, we see a lot of litigation over it. But even good people who make good loans and who document good business purpose loans are still getting caught up in it. The typical scenario is the borrower comes along, they want a loan, they say it's for a business purpose because they want to use this money to go ahead and invest to fix, buy another piece of property, to rent it out, or they want to fix up their rental property, but it turns out they actually live in that property, or it turns out that they actually are just using the money for their personal residence. The exposure is real. The exposure is that if you make a business purpose loan that the court deems is a consumer loan, you've now made a loan that's violated a variety of state and federal consumer loan statutes on the origination end. But at the same time, you may have done things on the servicing end that also violate the state laws when it comes to servicing consumer versus business purpose loans. So definitely there's monetary exposure, out of your pocket exposure for doing this. So the biggest thing I can recommend is make sure when you're buying these loans or when you're documenting these loans, make sure it's a legitimate business purpose to the extent you can. If it doesn't smell right, it's probably not right. Document that business purpose early and often at the origination of the loan, during the loan process, at closing of the loan. Make sure that it's actually the business purpose is the same at the front end and at the back end of the loan. I've actually seen documents where the business purpose was X when they originally asked for the loan, but then it's Y because they forgot what their lie was, and they go ahead and put a different one in there. So look at it at closing as well. And also, and then the biggest thing, and which I think is partly why all of you in this room, is trust your broker. Trust the broker that's bringing you the loan. If you don't trust the broker, then that's reason to be concerned. Doesn't mean it's bad, because you may learn to trust that broker, but just use brokers that you trust and do deals that you feel comfortable with. The next one is elder abuse claims. So elders are deemed anyone over 65. I'm not going to ask you to raise your hand if you're over 65. But traditionally, elder abuse we always thought of as it's the little 90-year-old lady who lacks capacity and she didn't know what she was signing, and that's historically what we dealt with elder abuse claims. This is different. This is anyone that's over 65. And the argument that's out there, and it's gaining quite a bit of traction with the judges, and also we're seeing more and more litigation, which is that elder abuse, defined by the statute, is when a lender takes or retains property of an elder for a wrongful use. It's pretty broad, pretty open. So they define wrongful use, which is further defined as when the lender knew or should have known that taking or retaining the real property is likely to harm the elder. Again, that's really broad and that's really open. So you can imagine that it'd be really easy for someone to file a lawsuit that says that you made this loan and it harmed the borrower because the interest rate was 12% or the interest rate was 13%. They may be wrong and we may prevail on it, but now we're in litigation and we're fighting and we're having to show that this loan actually benefited the borrower, that it was not harmful and it did not harm them in any way, which is expensive. The longer we have to argue in cases, the more expensive they are. So this is an issue that we're, again, seeing more and more often. And one of the attorneys that is filing a lot is Attorney Sil Vossler, good attorney. He knows his stuff, but he just had a big win, which he loves to brag about. There's a Brown case, $600,000 in damages. 2 loans were forgiven, and there's going to be another part of the trial which is going to discuss whether there should be punitive damages or treble damages, which is a fancy legal word for triple damages. Okay, so big exposure. Now, mind you, there's some scary sounding facts in that if they're all true, and which the court or the jury seem to think that they were true. Now, that's just a decision. It's going to go up on appeal. It's going to be challenged, and it may not ultimately stand. But it's out there now, and it has fueled the fire of these firms that want to file these lawsuits. So the practice tips is never loan to anyone over 65. That's the safest and simplest. Kidding. You can't do that. That violates different laws. So it is not that you can't lend to them, but look at those loans. I hate to say it, but look at those loans a little more carefully than you would look at other loans. You look at all your loans carefully, but look at those ones in particular as careful as you can. And then also watch out for pre-foreclosure demands. One thing we've seen on all the Silvosler cases is that he sends out a demand saying that this loan was the subject of elder abuse. He doesn't do that because he's a really good guy and he wants to put you on notice of it and help you out to prevent you from hurting yourself. He does that because he wants to put you on notice of it. So then if you go forward with your foreclosure, you are arguably increasing your damages. So if you see a letter talking about elder abuse, immediately reach out, contact your attorney. It could be BS, but it may have some merit to it, and you want to go ahead and take a look at it. And if any of you are going to ask the question, which we get often, is what if I'm over 65? Is that elder abuse back on me now that they talked me into doing this loan that I shouldn't have done? No, it's not, unfortunately. No, it does not go both ways. Although we argue it does. All right, last thing is some affirmative litigation. First, again, what I talked about before is most loans don't go into litigation. I just want to let you know what litigation is out there. California is still a great state to do trust deeds in, and it's still a great way to make money. But some do end up in litigation, so I want to let you know what's out there and some tips to try to avoid it. We're also seeing an uptick in affirmative litigation. So everything I talked about was defensive, where you're getting sued. This is affirmative. And some of this can be very useful for you. Guarantee actions. Up until probably a year and a half ago, it had been 5-10 years since I had tried to enforce a guarantee or send out a demand letter on a guarantee. Doing it almost weekly now. This is where you have your loan. It's to a single-purpose LLC. You have a guarantee. We send out a demand on the guarantee. It's a separate contract, separate obligation. It's a very useful option you have, and it really brings the borrowers back into working out their loan. Assignment of rents. If you have, in certain situations, you may want to put a receiver in place to collect rents. Judicial foreclosures. They're expensive, time-consuming, but the threat of a deficiency judgment really goes a long way in bringing the borrower to the table. And then fraud-related litigation. We're seeing a lot of fraud-related litigation right now against appraisers, borrowers, some bad brokers. And the last is title claims. Title companies don't like to pay title claims, and so often we have to push them, we have to sue them in order to get them to accept and do what they contracted to do. So those are some litigation trends that we're seeing. I think there'll be a Q&A later, and if anyone has any questions, feel free to let me know, and I'm going to pass it on to a much more interesting and dynamic speaker. Thank you, everyone.